be
Your own heart. It's 29.5.
EPA, counter plan, solvency, treaty.
Decision on prices during 2006 must be an and be possible 2006 to 2007 terms of jobs in October also has a court to go to fight abortion not school for fact due to damage global warming and Kennedy doesn't care about policy, he sees himself as a philosopher defending 2006 the fight of filthy judicial change when Kennedy sees himself more as a philosopher less likely to pull back since the course of dynamic from the law professors that the Kennedy would teach us at least to think because how to come to have an understated better and Kennedy's photograph he doesn't care about what people think ABC News 2006 I think he has a right track to record of the inferior to both sides sometimes said with the terms of other times about Alito's a swing vote for abortion case not Casey this is not Kennedy, this is going to that 6 and he also plays sister roles in abortion cases also on record upcoming abortion has to Alito other terms of valid because reproduces just to the counter swing vote and with the Alito back to late because it means the least amount of change created through policy. This means that they would have to put a link to Kennedy as the key vote which could change to do the affirmative. This is not which is not true because Alito would place to O'Connor Kennedy as the lead on the Casey majority decision which means his least likely to vote which is traditional and controversial decisions don't direct political capital and even if they did would be a reason to avoid doing the plan to emergency 94 there is no reason to believe the court's serious controversial decision on particular constitutional underwriting which ability even the dispute judicial work to decrease the judicial power in the realistic worth of words by intuition the constitutional form of sports political capital used to enforce the constitution plus the evidence about their impacts from the 1970s and indicates that we need to solve for fuel efficiency they have no time for more evidence of say we would be able to solve for this plus the kind of it's empirically denied by Hampton this is conservative voice in 2006 the Hampton held the president to have the authority over these private military commission case where the court should have the jurisdiction over policy to act to abrogate the ugly head the MacArthur says that the judicial ruling not for the president this position the court decision will have little impact on this is from MacArthur 2006 in the case where the political legal impact will for environmentally set up form of administrative procedure to be properly isolated and momental ability for carbon regulation is uneasy to sectors talking about the growth of the greenhouse gas regulation plus the court is not likely to give the states when this is Clean Air Act in 2006 the highly unlikely to go to implement climate change to the definition of the justice and the decision to be interested to court to blame to the plaintiff's area said that air was no that's it the ruling of the EPA wouldn't lead to any regulation of so long day with non-workable solutions to guarantee that the EPA takes blame for the inevitability compromise the best EPA in 1970 quickly with the dangerous to gasoline the agency still not the job until they become the EPA was hard to carbon dioxide regulation let's treat more complicated than the ability to pollution and even if the court goes the wrong way will lead to future regulation of GHG to stop your pipes anyways to clean air act report 2006 the court should have the nationwide over the global warming and intensify the political pressure for the CO2 control even if the entire court of the EPA the states are likely to continue to pursue their own climate change regulation regarding the current ruling the court to get EPA to CO2 limits would call for the intensify the congressional action to be able to stop more of those sorts of warming. Their arguments are rude and bureaucratic desire for calculation. This approach would be rejected in favor of embracing possibility of plans strongly to the left live into dangerous times of the future arbitrary possibilities to promise to economic collapse and additional purpose cultural warfare to system the proliferation of reasons for precisely the possibility of contributing to negative surrounding the first section they neither the optimist nor pessimist both sexual orientation negative approach to the promise test is to approach the possibility of reassuring the needs of the day not to the counterplan. First of all the counterplan doesn't solve any of the affirmative because they could see the cross examination is over with the court system one is even pretty fucking specific about how this is what allows for the types of regulations and oppression of women in the status quo which means that they have no internal link to solving for any type of political control or coercion of women and additionally they say that the piece of evidence that they read doesn't actually have any impact because the affirmative would change the way in which the family sector actually interacts with as well as the alternative actors don't solve for abortion rights the courts are key this is 2005 the court should move it after the fact to raise the charge immediately after the failed to back the time the court should raise the charge to the logical politician audience the political center case to see if this suggestion to prove an abysmal failure and the court solve best for except this is sin at all to this one does the purchase business policy and also the purpose to purchase the participants with the Supreme Court process changes the particular policy the greater policy terms of the Supreme Court because the court's greater legitimacy of these participants creates a very likelihood that the authoritative decision plus permutation do both and the permutation be able to solve for therefore this is permanent to 994 the widespread ability to contribute to family advance ideals discussed in cases of fever values the commercial action part of parental divisions the vulnerability states use intimidation of the bypass provision overruled the counter the rotary of the debating homes plus the court will never believe invalidate any congressional action feels would be a violation of case decision this is Washington Post 2006 the court's advantage of legislation by the legislation dislikes the new Congress to just appropriate and concurrent setting up the task to determine what Congress to do the homework situation invitation judicial arbitrariness the policy driven decision making plus the counterplans conditional to voting issue the feels traps and questions to investigate multiple worlds because the absence of shifting the argument becomes incoherent to dance around the possible double minded and B is to hurt education multiple worlds prevent the balance of debating any type of counter jury's advocacy to a good classroom around C is uniquely abusive for types of communities in the problem because they are running two different counterplans their alternative functions as the Supreme Court in doing the plan the judicial system reports to them like the resolution of legislative fees number just to leave perhaps majority unconstitutional plus the permutations often actually. Yeah, that's good. Psalm 2. First of all, Psalm 2 are linked to the county plan and their alternative, which means that there's no unique offense to biopowers not valid, because it's really specific about how the contextual use of biopowers is uniquely bad in the situation because it prevents women from getting abortions allowed to the men to control and say that the women are stupid or not able to have these types of decision making. They say we don't solve for it, but we solve the key types of aspects of biological laws in Monroe 2001 that have fear steps listening to the laws find out if you've done privately using for methodology to have the power to use by law for the case for legal before the faculty of powers are just for their first resisting actively within the legal sphere not only have the existing power structure but also the imminent possibility of existing through the change of legal change group. The next arguments about how the state restrictions to take an abortion are Fridays as well as the first piece of Article 1AC and indicate that the state restrictions are exactly how they're able to prevent people from getting types of abortion because the waiting periods and form requirements mean that poor rural women are not able to get to access to this. They say we can't solve for any backlash, but this is bullshit. We are able to solve for the types of acceptance crossed by the counterclaim answers as well as the fact that there's no impact to this and once you are doing both of those types of things, they say that with the case with the privacy decision, but this doesn't matter because we're not not regulating the type of it's based on the language which is she indicates it's not about the privacy, the way in which it's changed, it's about the language of sex language mandate. So we expand for agency, but this is not, there's no impact to this or reason why we would take out agency or affirmative indicates that we would solve for the good types of agency. They say radical change leads to a rule norm and then they read another piece of problems. This is the answer to our other app, not this app. We don't actually link, make, and prove reason why this is applicable. They say we take out agency, but this is determined by the variety of evidence and specificity of our affirmative evidence. They say essential, so that we don't essentialize, we create a new point for exposing exploitation. Well, this is what for 91. Here, Gregory believes the multiplicity of diversity essential to practice and expose the exploitation of common all of the five strategies for future war to dependent national job, social class, sexual experience from the form of pressure list, where the intimate and very close we prevent essentialism by naturalizing the view of women's negation of the for 91. The natural station conceals the absence of women. It's symbolic to bring the symbolic so far the essential gesture completely opposite to natural expression of women. So they will see the symbolic order at all plus the personal sexual difference guarantees extinction. This is here going to the exploitation of based on sexual difference all result from sexual difference or tendency of the baby so contemporary feminist mostly demanding denaturalization of sexual naturalization corresponds to the human race, the race is defined to reproduction, reproduction, trying to repress sexual differences to and fight genocide more radical structure never existed in history. What is indispensable African culture, sexual difference not again exists with both the types of traumas. They say that we ignore the discrimination, but the evidence doesn't actually conclude that we ignore these types of discrimination, other types of things. We indicate that we are key to solving for one aspect. It does not mean that we cannot talk about other types of pregnancy or genetics and make turns to that. I've already explained about they say that it takes out medical rights, but PC is what gives rights to people who allow for them to have these types of discussions. They say black and the backlash, this is all the issue about their evidence is not in the context of us overturning the cases now to the criticism. First of all, the criticism, we don't link to your criticism. The Supreme Court is an institution. Your evidence doesn't make a contextual analysis between an institution versus a subject object position of the person. Additionally, you are not able to solve because the language exists in the status quo and it will continue to exist after the alternative. There's no reason why unique rejection of our interpretation is the best plus permutation of all this is able to solve for any risk of offense. They say alternative, but they can see that the alternative wouldn't be able to solve for the affirmative press by the arguments in the counterclaims plus the alternative that takes your reason to you rejected first of all limits the ground to describe the claim kills the ability to make revolver on presumption kills the advantage to level to experience the burden solves if you counterclaim of a real world comparison is relevant because it is a real theory question to be provided on a level playing field. The picture shows these types of balance. Additionally, the permutation is able to solve because our interpretation of ethics navigates responsibility between the other and us and refusal to be weighed down specific values is served to the 98. Important and to mention Erica's work in sexual difference on debates and ethics meditation by the ethical inquiry nation head of physically lifting head of the Erica's refusal to herself decide to find virgin to the absolute responsibility of evidence of the transcendence of the obligatory from the established to regard the ethics of the sexual difference and native trajectories to beginning without the application together responsibility to differ sexually social beginning by contesting the opposite between the carnal passion ethical application of sex together becoming itself the Erica opens distinction between the two main ethical trajectories supposed to find the way to negotiate between the two of them plus the affirmative radical break with temporality when you should view the plan as opening a new space and time is not based on predetermined decisions. Is zero and any instances the wonder and allows us to present the breakdown of actualization predetermined conditions. The good consistently defines the passion for all the wonder and open up the new space and wondering true link to death and now found the time radical nationalist for called simplicity to the bursting of the creating this is the dimension of the but in terms of sentences a sort of ontological genesis with rejection of the knowledge control for the blood to suffer the place your groups emphasis on the rupture of last and the positive suspension past determination what you feel the indeterminacy of the history about the correspondence time and place which it has typically limited to go around a circle plus debates over these types of things are inevitable which means you should vote for the affirmative this is commonly the academic left leads to debate and physical this blood left rejection left producing hopefully something and intensity that seeks to have to punch across these will make objective about our exclusionary policy.
Are any of those cards you just read specific to the I-it versus I-thou relationship?
Specific to your impacts.
What?
Let me get this straight. You just read a bunch of cards on why our metaphysical assumptions and talking about words and epistemologies isn't important.
No,
Your answer to our counterplan is you don't overrule the language of the court.
Okay.
All our
I have another
cases
question.
really don't matter.
Okay, let's talk about your counterplan answers. The first card that you read
says the pro-choice movement must confront the fact that embracing a strategy that is mainly electoral has failed to turn the tide back in favor of abortion rights. So in the status quo, we haven't been able through elections to win abortion rights. Why does that answer the
Through
counterpoint?
Congress, we have not. Sorry. Through Congress, we have not been able to grant the types of abortion rights that are necessary, especially in the context of the
Okay,
affirmative.
in this quo, how does this answer the counterpoint?
Because it indicates that Congress is not able to solve for these types of movements. We have other evidence that we read which indicates that the Supreme Court is the key point of access to get any type of abortion rights
okay.
because people view it as more legitimate,
Next
not
card.
the child of bureaucracy.
Okay. Next card. You read a Clausen card which says that policies that are child of the bureaucracy have greater propensity to inspire protest than policies in the Supreme Court. Is this
Right.
is this evidence specific to abortion or Congress?
It's specific to Supreme Court ruling on issues
Well,
and
yeah.
overruling.
It says Supreme Court better than bureaucracy. What about Supreme Court versus Congress?
I would argue that Congress is pretty bureaucratic.
Okay, but this evidence assumes agencies, which are a
It-
separate branch of the government.
It indicates that the way in which the Congress
Okay.
is ruling. We'll read other
Your
cards
firm
that
solvency
argue
card says,
that way.
the widespread decay of the institution of family demands that the ideals espoused in Casey be reevaluated through congressional action, and that the entire parental consent and bypass provision be overruled.
Yes, the
Okay,
other
so
part of
why
it says
does
that
this
you
say
need to
Congress
have
is
court
assault?
and congressional action, which would be the reason why the permutation is
This
sought.
card
The
says
part
that
you're not
Congress
reading,
can effectively do
It
that.
says Congress and the courts need to work together. The part that you're refusing to read says that.
Okay. Next card. You read a card that says the court will invalidate any congressional action. Is this
Yes.
evidence specific to abortion?
It is specific to court precedent. When Congress tries to overrule it, it would say
It
that
says it's
If
the
this is
court
proven
will
by
overrule if
things-
Congress plucks out of the air a brand new doctrine. Is this specific to the Freedom of Choice Act?
That evidence is specific to when the Supreme Court has set a precedent and Congress tries to overrule that precedent. That
Okay, do you read
evidence
any evidence that the Freedom of Choice Act is not consistent with the Casey precedent?
It is not. We don't read any evidence of that.
Okay. Last card, you say that the court should rule and the Congress shouldn't. This evidence cites, quotes Scalia, and says that it's unrealistic.
I don't remember which card you have.
This Bamberger card,
Yeah.
what is the warrant this evidence?
What was the? I'm sorry,
Okay.
I just don't remember which card.
This
it
evidence
was.
says it would be viewed by Scalia as unconstitutional. Does that evidence assume
Oh, yeah.
increasing access?
Yeah, it says
opposed
that
to overruling abortion rights?
when Congress would rule on types of abortion rights, the court would see it as
Right.
unconstitutional
So if
because it would
Congress
be a violation
violated
of
or
things like the
restricted abortion
Casey.
rights. Right.
No, right. It would see because the court upheld the restrictions in Casey as constitutional. So
Well,
if the court
right.
got
It says it wasn't unconstitutional, but the Casey decision did not say they had to have that restriction.